The court will find and rule as follows. The question is whether or not the state has proven by clear and convincing evidence that there are no release conditions that would reasonably protect the safety of any other person or the community. It's broken down into the three-part analysis articulated in State v. Groves, and in that analysis, the court considers the factors enumerated in Rule 549-6 as required by State v. Anderson. The first question is whether or not the information proffered carries sufficient indicia of reliability to be worthy of consideration. I do find that the state's 6 exhibits and the defendant's 28 exhibits and the court's 2 exhibits and the testimony offered today are reliable for purposes of this decision. The next question is the dangerousness question, the extent to which that information indicates that the defendant may likely pose a threat to the safety of others if released pending trial. I'll back up and note that probable cause was found by the Metropolitan Court judge. We're not set for a preliminary hearing today. I do find that that is sufficient for a probable cause finding for today's purposes. So, as to the dangerousness question, based on the nature and circumstances of the present offense, noting that this is a crime where the allegations involve criminal sexual contact of minor children in the general areas, I do find that is inherently dangerous. So I'm satisfied based on those that the state has proven that Mr. Busfield does pose a danger to the safety of others. As to the last question, whether there are any potential pretrial release conditions that would reasonably protect the safety of others, I'll work my way through the F6 factors, first adopting my findings about the nature and circumstances of the present offense. I'll move on to the weight of the evidence. Now, Ms. Brandenburg-Koch is right. It's important to acknowledge the nature of sexual assault cases, and delays in reporting, especially from minor alleged victims, are fairly common. That sort of sexual abuse often occurs in the dark. This situation is a little different in that the allegations involve the defendant being alleged to have committed these acts on a film set. Now, the defendant's presentation, the affidavits from a number of people who worked on that film set, the independent investigation performed by the law firm hired by Warner Brothers, the testimony offered today do not corroborate the allegations offered by the alleged victims in this case. Now, while true, the statement from those children to law enforcement initially and expressly denied that anything occurred, the children then subsequently reported these things. That's not uncommon. As it stands today, based on the limited information I have in front of me, I'll characterize the weight of the evidence against the defendant as neutral at this point in time. As to the defendant's history and characteristics, as included or reflected in Court's Exhibit 1, this defendant exhibits 0 criminal history, no misdemeanor or felony history. The state has brought forth a number of allegations over the last 30 years, something of a pattern involving allegations of this defendant committing some sort of sexual contact against post-pubescent women. Now, these allegations have not been vetted by the judicial system for various reasons. There being a civil settlement in one of those, a declined prosecution, or no action taken on the exchange of the defendant engaging in therapy. I understand that, given the media attention to this case, that more people may come forward with other allegations supporting this pattern. But at this point in time, it's difficult for the court to put too much weight into those allegations as they've not been vetted by the judicial system. I'm concerned about the allegations of this defendant using his position of power on the film set to advance his own personal motive. But the affidavits offered by other people working on the film set do not show that Mr. Busfield has used or abused that position of power. With regards to the nature and seriousness of the danger posed, I'm very mindful of the higher court's guidance in the Begay case, in weighing this defendant's risk of reoffending. But given the lack of a pattern involving children in this case, I think that can be remedied through different conditions of release. For factor E, I don't find that there's been sufficient presentation that this defendant may commit new crimes if released pending trial. There's no evidence of a pattern of criminal conduct. There are no similar allegations involving children in his past. There's no evidence of non-compliance with prior court orders. Rather, this defendant self-surrendered and submitted himself to this court's jurisdiction, demonstrating compliance with the court order for his arrest. There's not been any prior pretrial detention finding. So on the balance, I cannot find that the state has proven by clear and convincing evidence that there are no release conditions that would reasonably protect the safety of any other person in the community. So I am denying the state's motion. I'll take care of that order. That'll be published tomorrow. So Mr. Busfield, I'll set the following conditions of release. You're authorized for release under our recognizance with the conditions that you appear at all future court settings, do not violate any laws. You'll be supervised by pretrial services here in Albuquerque at a level 2. I'm not going to prohibit your travel. I understand you may not live here, but you will need to report to pretrial services here. You're not to possess any firearms or dangerous weapons. You're not to possess or consume any alcohol or illegal drugs. You must notify the court of your address. You're not to have any contact with the alleged victims or their families, and you're also not to discuss the case with any witnesses. That's what the attorneys and their investigators are there to do, and we can't have you tamper with any of that. And then you need to maintain weekly contact with your attorney in this case. So, Mr. Busfield, do you have any questions for me about what any of those conditions mean?
No, sir.
Okay. So, attorneys, I'll take care of that order tomorrow. Is there anything else the state would request, Ms. Brandenburg?
Good. I would ask for no contact with children under the age of 18.
Oh, yeah, sorry. No unsupervised contact with any minor children in this case. Mr. Dodd, any other conditions you'd request?
No, Your Honor. I would ask just if the court can get that filed through your TCA today so that I can...
Oh, this conditions of release? Yeah.
Yes.
I've already... Yeah.
Oh, perfect.
That'll be filed today.
Thank
I'll take care of the full detention order tomorrow. And so with that, anything else, state?
Not at this time, Your Honor.
In defense?
No, Your Honor. Thank you very much.
Okay, thank you all. We'll be adjourned.
All rise.
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.